So how do you stop your kids from fighting over your assets when you're gone? Hi, my name's Edmund.
I'm Jennifer.
I'm Cindy.
We're the attorneys here at Amity Law Group. As a law firm, we're known for helping protect families with tools like the living trust and other estate planning documents. So for this particular video, we wanted to help you stop your kids from fighting over your assets. We see this a lot with kids that don't get along when they're young, when they're old, and when their parents pass. They want everything, right? One of them wants everything, one of them doesn't want particular things. And so how do you stop kids from fighting like that? Because that causes a lot of problems. So Jennifer, what are some of the problems that this scenario causes?
Well, so it's potential for lawsuit, right? So if one child believes that they were somehow, it was unfair to the distribution, or somehow they believed that they were supposed to receive something from the inheritance, and it wasn't necessarily the way they thought it would be, they can try to bring a lawsuit against the estate, against the other sibling. Even prior to the lawsuit, there would probably be a lot of just disagreement and fighting within the siblings. And so, we do want to avoid these type of situations. We've had clients come in, parents, they say, I do want to be fair to my kids, but this kid has went above and beyond taking care of us as we have gotten older. This child, spends a lot of his or her time with us, but the other one is just, I see her or him maybe once a year or even less. And so I do let them know that, as owners of assets, it's within your right to decide who you want to leave your assets to. You don't necessarily have to be equal to your children. There's no law about that. It's really, really up to you. But I think the one thing that we do emphasize is that you make it very clear as to who you're leaving your assets to, and within your living trust, which is what we would assist with in making sure that it's black and white. There's writing to ensure that your intent is understood, and it's notarized, it's a legal document. There's no question as to why you may have left a child out of your inheritance.
Yeah, it's really important to be clear. I mean, I had one client who, it was the daughter. The daughter was the client. She was the administrator of the estate. The parents had left the house, but there was a particular sibling who felt like she was entitled to all of it. So it obviously developed into a lawsuit, and we had to eventually, figure out a way to try and settle everyone's interests. But it was just very unnecessary if the parents had made it clear before that passed what each child would receive. And sometimes, it might be prudent for a parent who knows that for a fact there will be issues that will arise when they pass, that they try to solve those issues before leaving. So, and how do you do that? You do that by having family meetings and by being very verbal and open about where you stand with your assets and how you want to distribute your assets. So as attorneys, we will put it in black and white, but it's also very important that you convey this to your children, especially when you still have the mental capacity to do so.
Yeah, and it's something that we provide a setting for. So if you feel like, hey, you're coming to finalize your estate plan, your living trust, you want your kids present so they are aware of what you've planned, then there's really no question about it later on. So it might not be a very pleasant meeting, at least for the one that's not getting anything, but at least they are informed, while you're making your estate plan, finalizing your estate plan in front of the attorney, that they're aware, hey, my parents are not going to leave me the entire house. And we are open to that. We provide the setting. We provide, a time for your family to come into our office and have these meetings, and we can be present or not. It's up to you whether or not you feel the need for us to step in and kind of explain your estate plan, and we're open to that as well.
And a powerful tool that we use for our clients in their living trust is we add what's called a no contest clause. What that means is it's written in your living trust, and it stops your children potentially from bringing these lawsuits, because what the clause says is if any of the children contest some of the provisions, any of the provisions in your living trust, then they get nothing. So let's say you give 30% to your son and 70% to your daughter, and the son wants at least 50%. So he challenges your trust and says, hey mom, I want you to give me 50%. And that clause would say that if he loses that argument, then he's going to get nothing. So his 30% gets wiped down to zero. And a lot of times that prevents kids from challenging their parents' words to mess everything up. And so that's a really good tool that we use, and we put that in for our clients. All right, I think that's it for this video. Thank you for watching. If you have any questions about living trust and estate planning, give us a call. We offer free consultations. Until next time, have a great day and take care.